Good morning, everyone. Thank you so much for joining us today for our latest edition of Recent Cases of Interest. My name is Natasha Dunker. I'm Communications Director for PERAC. And this morning, our presenters are Ken Hill, our Assistant Deputy Director, and Felicia McGinniss, our Associate General Counsel. Today's webinar will earn you 3 credits. If you are a board member, you will automatically receive those credits in Prosper. You can check your account in approximately 1 week, and it should be automatically updated. You do not need to do anything for that. We are also recording this webinar, so any board members who were unable to join today can watch the recording in 2024 to receive credits. We will take questions at the end of each presentation. If you would like to type the questions into the Q&A section, as you think of them, please do so, and I will read them off to Ken and Felicia at the end of their respective presentations. And with that, I will turn it over to Ken Hill. Also, I will drop the handout link in the chat if you were unable to download it through the email. All right, thank you. Here's Ken.
Thank you, Natasha. And thank you to everyone who's attending today. We appreciate it. As Natasha said, we're presenting on recent cases of interest. These are cases that it's a mixture. We've chosen them. Some are pretty basic, but they're cases that you'll run across similar fact patterns. And then we also have a few cases that you'll never run across, but we hope you find interesting. As Natasha also said, we will be taking questions. I just ask that because we're presenting on particular fact patterns of these cases, you not hit us with any hypotheticals because we're not really prepared to answer those. We're prepared to talk about these cases. Also, one case, and if you have specific questions or you do have a hypothetical situation, feel free to email either I or Felicia, and we'll get back to you with the best answer we can. Also, there was a recent case decided by the appeals court, the Hullop v. Worcester Retirement Board and Crabb case. We will not be presenting on that today. The reason being that PERAC is actually working on a memo to go out to all the boards regarding the implementation of that case. So that will be coming in the forthcoming weeks. Finally, before I begin, is both Felicia and I are going to be using the words DALA and CRAB frequently. And for those who don't know, those are the administrative agencies where appeals are heard. DALA is the Division of Administrative Law Appeals, and CRAB is the Contributory Retirement Appeal Board. So I just wanted to throw that out there before we just start throwing out those acronyms. Okay, and on to my first case, the Tuminelli v. the Somerville Retirement Board case. In this matter, Mr. Tuminelli was a member of the Lynn retirement system, and he injured his leg very badly. He had to have multiple surgeries. Eventually, he left that job and took a job working for Somerville and became a member of the Somerville retirement system. Unfortunately, soon into his tenure in Somerville, his leg issues returned and he had to have multiple surgeries again. He was never really able to work long in Somerville, maybe about 3 months. And after about a year, the pain became too bad and he had to resign. And he became an inactive member of the Somerville retirement system. Soon after resigning, this is in about 2013, so a long time ago, he applied for accidental disability retirement from the Lynn retirement system because that was the system where he sustained his injury. The Lynn Retirement Board denied his application and they argued that he was not permanently disabled on his last day of work with their system. Mr. Tuminelli appealed that decision to DALA. In 2020, DALA reversed the board's decision and granted him ADR. But then in an unusual situation, DALA then reconsidered and determined that he should have filed the application with the Somerville retirement system. He appealed that decision to CRAB, where it remains pending at this time. While it's pending at CRAB, he filed an application for accidental disability with the Somerville retirement system. The board denied his application, They essentially found that he wasn't injured while working for Somerville. And the fact that the pertinent statute, which is section 7.5, states that if he was injured while a member of a different system, he must file in the system where he was, quote, presently employed. The Somerville retirement system argued that he was not presently employed by Somerville because he was inactive. When he filed his application, he was inactive. Poor Mr. Tuminelli had to appeal that decision to Dalla, and this is the recent decision. Dalla found that, well, they found that if Somerville's argument was to be accepted, Mr. Tuminelli is in, as they put it, no man's land. They noted when there's only one system involved, section 7.1 does not require that the applicant be presently employed in the system. You can file when inactive. And there was no evidence that presently employed should be required when there are two or more systems. They essentially ruled that the phrase presently employed means the most recent system you were a member of. Okay? This has been appealed to CRAB from Dalla, where it is pending. So poor Mr. Tuminelli has two matters pending at CRAB just to get his accidental disability, which doesn't seem to be in dispute that he is, it doesn't seem to be in dispute that he is permanently disabled. So I wish him the best of luck, and that we get some law out of this to give us all some direction. But that is the situation now. The next case I will present on is, I don't know if I'm pronouncing it right, but I would say Crichton v. the State Board of Retirement and PERAC. Now, this is a situation that you might run into, okay? When a public safety person applies for ADR, when I say ADR, I mean accidental disability retirement. When they apply for ADR under the heart presumption, the statute requires the inclusion of a pre-employment physical. And this pre-employment physical must show no evidence of a heart condition or hypertension at the time of hiring. In this situation here, Mr. Crichton was a corrections officer. His pre-employment physical showed evidence of hypertension, and the board found him ineligible for the heart law presumption. He appealed to Dalla, and he argued that his disabling condition right now is not hypertension. It is aortic dissection, which was not present prior to his hiring or in his pre-employment physical. So he argued, yes, there was hypertension in my pre-employment physical, but I'm not going out for hypertension. I'm going out for aortic dissection. Dalla ruled that the presence of the hypertension, however, at the time of his hiring, makes the presumption automatically inoperable, regardless of what the disabling condition is. They also noted that he could have applied for a Section 7 accidental disability retirement, but the fact that he chose not to do so was indicative that there was no workplace injury that caused the aortic dissection. And Mr. Crichton has appealed that decision to CRAB, where it is pending. Okay, this is a case that it's the Wakefield Retirement Board versus the Mass Teachers Retirement Board. Section 3.8c, okay, permits a retirement system to seek proportional reimbursement from any previous retirement system a member may have belonged. Okay, you have to request, the board has to request it. So 3.8c says if you were, you retired from our system, but you had many years in a different system, so they owe a proportion of the liability. Here, there were two former members of the Wakefield retirement system who later became members of the Mass Teachers retirement system, and they retired from the Teachers retirement system. About 20 years after their retirements, Mass Teachers invoiced the Wakefield retirement system for its proportionate shares for the members pursuant to 3.8c. And Wakefield retirement system paid those invoices in full. Now, in Massachusetts, there are statutes of limitations for certain actions, okay? There is a statute of limitations for maintaining an action in contract, and that is 6 years. Okay, so if it's a contractual argument, you need to make it within 6 years. You only get 6 years, basically. Wakefield realized this and argued that MTRS was only entitled to 6 years worth of payments, not the 20 that they sought and received. Well, MTRS declined to issue a refund, and the Wakefield retirement system appealed to DALA. DALA determined that the 6-year statute of limitations is applicable, but it can be relinquished or forfeited. And that is what the Wakefield retirement system did here. By paying it, they forfeited their right to make the statute of limitations argument. DALA found that the math teachers was rightfully owed the entire amounts, so there was nothing legally wrong in their collecting it. It was a valid and enforceable debt, notwithstanding the statute of limitations. And there was no error here in their requesting it or it being paid. So the 6-year statute of limitations is applicable, but because it wasn't utilized here, they forfeited the use of it. And this is a final decision. As some of you may be aware, I gave a presentation at the most recent McGinniss convention in Springfield. And part of my presentation had to do with making sure that people updated their beneficiary forms. This case illustrates why it's so important to do so. This member was in a long-standing relationship. When he entered service with the state in 2005, he named his partner, Mr. Robbins, as his sole option B beneficiary. It was properly witnessed and accepted by the board. It did not, however, include any proportionate share that was to go to Mr. Robbins. He was the only beneficiary named, but it did not say what proportionate share he should be getting. But again, it was accepted and witnessed by the board. In 2019, the couple broke off their relationship. They sold their home and they went their separate ways. And unfortunately, the member died about a year later. He never updated his beneficiary form, however. After his death, his sisters argued that their brother would never have wanted Mr. Robbins to be his beneficiary at that time. They provided affidavits, to this effect. And they noted that he had removed Mr. Robbins from a life insurance policy he was on. And the board determined that the form itself that he filled out was invalid, okay, because he did not complete the proportionate benefit section of the form. And as a result, the board was going to make the final payment to the funds of his estate. Mr. Robbins appealed that decision to DALA. DALA noted in its decision that if a beneficiary form is missing a witness signature, it is a fatal omission that nullifies the form. But it should be given its full effect if it's, as they put it, substantially complies with the board's rules and the intent is unambiguous. Here, DALA found the form substantially complied and was unambiguous. And invalidating it, as the board did, because there was no proportionate allocation, was unduly harsh. He identified Mr. Robbins as his sole beneficiary. So there was no need to designate proportions. If there's only one there, they would get 100%. It basically, DALA said that's common sense. And they noted that the relevant inquiry goes to the member's intent when he filed the form, not upon his death. And it was obvious that his intent was for Mr. Robbins to get this benefit at the time he filed the form. He could have changed that benefit prior to his death, but he did not do so. So the intent was obvious. And this is a final decision. The next case is Roy versus the State Board of Retirement. This is a fairly common case. This is the kind of case that can be referred to as sticker shock. In a nutshell, the member left service and got a refund of her total deductions. That was in March of 2004. She was notified that she would not get credit for such service unless she paid back the withdrawn funds with regular interest. And that refund amount was about $6,400. Well, she returned to service in July of 2004, just 4 months after taking the refund. She worked. In 2011, the legislature amended the statute so that any service purchase not completed by April 2, 2013 would be subject to quote unquote actuarial assumed interest, which is higher than regular interest, much higher, significantly higher. Well, in 2019, in anticipation of her retirement, she sought to buy back her prior service and was told that the actuarial assumed interest would need to be applied. She was given that rate, given that rate of the actuarial assumed interest and the passage of 15 years, she was told that the buyback amount would be $24,000, which is about 4 times what she withdrew. That's when the sticker shock hit. She appealed and basically argued that, she was told regular interest rate should apply. And Dalla found that, unfortunately, the statute is unambiguous that actuarial assumed interest should apply for any buyback not completed after that date in 2013. And they felt sorry for her. They understood the sticker shock, but the statute's unambiguous, and Dalla does not have the ability to create an equitable remedy. So unfortunately, either she paid the $24,000 or she does not get credit for that time she worked. And it was not appealed, and it is a final decision. The next case is Robinson v. the State Board of Retirement. This is a fairly common type case. It involves a state police dispatcher, which I always find there's a crazy percentage of cases out there that involve dispatchers. I don't know why, but back to it. To be basic for a moment, when a member retires from public service, their retirement allowance is based on their age, their years of credible service, their salary, and a group classification. And depending on your group classification, you can retire at different times. Essentially, the higher your group classification, the earlier you can retire. Section 32G provides the criteria for determining your group class. Most of us are group 1. That's the catch-all provision. And that leads us to Mrs. Robinson. As I said, she was a state police dispatcher. Dispatchers are not listed as having group 2 status in section 32G. But that statute does list what are called police signal operators and signal maintenance repairmen. Now, there's a long line of cases, Raposo being the key one, a long line of cases that have held that dispatchers do not qualify as those jobs because the duties and hazards of those jobs that are mentioned in 32G involve certain dangers that a dispatcher does not incur. Being out in traffic, electrical problems, weather, all these dangers that regular dispatchers that work in an office don't ever incur. Mrs. Robinson, however, took it a step further. She acknowledged that, but she took it a step further. She argued that her duties as a state police dispatcher were different than your typical municipal dispatcher because she was, sometimes she was exposed to dangers, including occasionally having to be at on-scene command posts and occasionally being near prisoners in cell blocks. Dalla was not swayed, however. The dangers that she cited seemed to be very infrequent, and that her typical duties were similar to a municipal dispatcher working in an office. And moreover, the dangers that she cited were not any of the dangers that are listed in the bullet point 4. So she was denied Group 2 status, and this is a final decision. This is a sad case. This is Mr. McDonald v. the Norfolk County Retirement Board. Mr. McDonald was a police officer. 2014, he injured his knee while on duty. He was able to return to work several months later, however. In 2019, 5 years later, his knee or knees buckled under him, which caused him to fall, and he hit his head. He was taken to the hospital, and he was initially diagnosed with intracranial hemorrhages, and then he was diagnosed with brain cancer, and he died less than a month later. The death certificate listed the immediate cause as intracranial hypertension due to brain metastases. Several months later, his widowed wife, Mrs. McDonald, applied for death benefits pursuant to Section 9. With her application, she included an IME, an independent medical examination, from a neurosurgeon, saying that the knee injury may have caused him to fall and possibly accelerated his death. The board asked PERAC to retain a neurologist to conduct a different IME. That doctor concluded that his lack of stability was caused by the intracranial pressure and not by the knee injury, and that the evidence was that there were multiple falls in the days leading up to his death and that they involved both knees buckling, not just the knee he injured. The board denied her application, and she appealed to DALA. She argued that the board should have requested a full medical panel of 3 doctors. DALA dismissed that argument because Section 6 and 7 for ordinary and accidental disability, they mandate that you need a medical panel of the 3 doctors, but Section 9 does not require a medical panel. DALA further found that in comparing the 2 IMEs that were submitted, it was clear that the IME by the PERAC doctor was stronger. It contained far more conviction and diagnoses that the knee injury was not a part of the reason why poor Mr. McDonald fell. And DALA found that the application was properly denied because the board did not receive proper proof under Section 9, and the knee injury was not the proximate cause of his death. It was unfortunately the brain cancer was the proximate cause. And this was not appealed and is a final decision. Again, going back to the McGinniss conference in Springfield, I touched on this case lightly during my presentation. It's about the interplay between Section 11C and Section 12(2)D. That's what I presented on. But in a nutshell, prior to retirement, you can name a beneficiary under Section 11 to receive a return of your accumulated deductions. You can also name a Section 12(2)D beneficiary who, if certain circumstances are met, can receive a lifetime benefit. Only one of those benefits gets paid, however. And a Section 12(2)D trumps a Section 11 beneficiary. However, if you're married and meet certain criteria, a spouse can trump a named Section 12(2)D beneficiary. Those conditions are: you need to have been married for over 1 year, and you need to be living together on the date of death. Or if not, you were living apart for justifiable cause. Now that brings us to this case. Here, Mr. DeFeritis named his wife as his Section 11 beneficiary, but he did not name anyone as his option D. Marital issues happened, and Mrs. DeFeritis moved out of the marital home. They never technically divorced, however. Unfortunately, he died while in service. Mrs. DeFeritis attempted to elect the option D benefit as his spouse. The board denied it because they were living apart. The issue before DALA was whether they were living apart for justifiable cause. Usually, justifiable cause is when one of the spouses unfortunately has to live in a nursing home or something like that, or military deployment overseas. Those are the typical justifiable cause reasons. Here, Dalla found there was no justifiable cause, that they were living apart because of, as they put it, mutual consent. So she was not eligible for the spousal election. To make matters worse, she was not even eligible for the Section 11 because Mr. DeFeritis had a son from a prior marriage, and Section 12B provides that in this type of situation, the Option D benefit shall be paid to the surviving children until they reach age 18 or 22 if a full-time student. So Mrs. DeFeritis did not get anything in this situation, unfortunately for her. And this is a final decision. It was not appealed. The next case is Briley v. PERAC. This is a very, very sad situation. Officer Briley attended a training session on defensive tactics. Okay, it was a combination of classroom setting and also, hand-to-hand, learning new techniques and whatnot, where, one partner would act as the aggressor and the other partner would work, their partner would work as basically the police officer in diffusing the aggressor. Well, he attended that class, and a few hours later, he reported for his overnight shift. Very unfortunately, he was found dead in his police cruiser in the parking lot of the police station several hours later. An autopsy was performed, and he was found to have died from cardiovascular disease. His widow applied for and was awarded death benefits pursuant to Section 9. She also applied for benefits under Section 100. Section 100 is an enhanced benefit for public safety killed in the line of duty. Now, at the time of his death, Section 100 provided a benefit for police officers killed in the line of duty and as the result of an assault on his person or as a result of an accident involving a police department vehicle. So that is the criteria at that time. At the request of the board, PERAC retained a doctor to examine the records, and he opined that Mr. Briley likely died of pre-existing heart disease, and that there was no evidence of an assault. Despite this, the board voted to approve the application for the Section 100. PERAC unfortunately had to remand that decision, and it was appealed to Dalla. Dalla ruled that the word assault is unambiguous, and it is not synonymous with incident, as argued by the board. There was no evidence he was assaulted while at the training. It was a consensual class that he attended, and there was no assaulter, okay, that could have committed an assault. And noted that the training class was just a simulation, and they denied the Section 100 application. The statute, although it would not have helped Mrs. Briley in this situation, Section 100 has been amended following the very, very unfortunate death in Worcester of Officer Manny Familia, where he tried to rescue a child who was drowning, and he unfortunately drowned himself. Under the language that Section 100 had, he would not have been eligible for the 100 either. So it was recently expanded to include the phrase, or at the scene of an emergency. Officer Familia was able to get it. But again, this would not have helped Mrs. Briley because he was not at the scene of an emergency. But unfortunately, that's the situation here, and it is a final decision. The next case I will present on is Pereira v. the State Board of Retirement and the Fall River Retirement System. Before getting into that, as virtually all of you know, in 2009 and 2011, significant changes were made to the pension laws. It's part of pension reform. Well, many of those changes were kind of open to interpretation, and there wasn't any case law to look on. Well, now we're starting to get some case law that can provide us all with some guidance, and this is one of those cases. So one of those legislative changes involved the dual member provision of Section 52E, requiring that if you were a member of two systems, you had to retire separately from each system. Another one concerned the so-called year for a day provision, which was revoked. Before it was revoked, you used to get credit for a full year's service, even though you only possibly worked one day in that year. Brings us to our situation here. Ms. Pereira was a member of two retirement systems prior to pension reform legislation. She argued that pursuant to Section 25(5), she had a contractual expectation that the law as it was written upon her entry into service would apply when she sought retirement. Okay? And the pension reform changes, she argued, broke that contract. She wanted the dual member provision to not apply to her and the year for a day provision to apply for her. She argued that had the changes not happened, she could have retired earlier and at a higher benefit, like she expected when she became a member. Crabb, okay, because this was appealed from Dalla to Crabb. Crabb gave a detailed analysis of the justification and reasons for the legislative changes. They noted it was primarily due to the economy and the fiscal viability of the pension systems, and determined that the legislature's reasons bore a reasonable and material relationship to the successful operation of the pension systems. And that were saved by the legislature's reserved police powers. So, in my opinion, Mrs. Pereira came up with a very good argument. However, Crabb had a very detailed and appropriate decision in this matter. I recommend that everyone take a look at that decision as well, which is a final decision. It was not appealed any further. The next case is Stanton v. State Board of Retirement. This is another decision that has to do with the anti-spiking, and it is related to the Pereira case in terms of its argument. But by way of background, Mr. Stanton worked for UMass. He stopped working in 2008, and he deferred his retirement until 2018. His highest 3 years were 2006 through 2008. Pursuant to changes to the pension law, the board applied what called the anti-spiking provisions that were added to the law in 2011. And he was found to trip those provisions, resulting in a lowering of his pension. Basically, his compensation in one of those years exceeded the average annual compensation in the two preceding years by more than 10%. This change was intended to prevent a big raise at the end of your career, which would artificially inflate your pension. Excuse me. Similar to, okay, excuse me. He argued the same as Mrs. Pereira. He argued that under Section 25(5), he had a contractual expectation that the law as it applied when he became a member would be applied to him, and that this legislative change broke that contract. Similar to the Pereira case, Crabb found that the anti-spiking provisions did not change that original contract because they were permitted via the police powers of the legislature, and they had a viable reason for doing so. This matter has been appealed to the Superior Court. I wouldn't be surprised if it eventually goes to the appeals court, and then we would have incredible precedent going forward. I mean, if Mr. Stanton were to win in this case, at the appeals court level, I mean, it's possible that the anti-spiking and all the other changes made in 2009 and 2011, maybe they wouldn't be applicable to anyone who was a member before then. But getting ahead of ourselves, as I said, this is appeal to the Superior Court, and it may end there, and who knows what they'll determine. But you might want to keep an eye on it. And the final case that I'll present on, and actually it's their companion cases. This is Willett in Houston versus the Somerville Retirement Board in PERAC. Once again, this involves pension reform. These are anti-spiking cases as well. In this situation, the city of Somerville conducted a review of employee compensation to determine whether employees were being paid their proper salaries. That's a good thing. It resulted in raises for these two employees. They both put in their retirement papers soon after. And however, they tripped the anti-spiking provisions of Section 52F. They argued, however, that they met one of the exceptions to 52F because their salaries were specified by law. Indeed, as a result of the salary survey, the city council did pass ordinances approving the increases. Okay. PERAC had argued that an ordinance is not specified by law as intended by the statute. That was appealed. It was appealed to Dalla, and then it was appealed to Crabb, and we got the decision here. And Crabb ruled that the ordinances satisfied the requirement of being specified by law. PERAC did not appeal this, neither did Somerville Retirement Board. It's a final decision. The survey on the salary survey and an increase on its own likely would not have been sufficient to satisfy the exception of specified by law. But the fact that they put the increases into the ordinance is what saved it here and allowed well, I'm not sure if it's a man or woman, it allowed the parties to argue that the exception applied, and so anti-spiking was not applicable to them. And as I said, it's a final decision. So that is the conclusion of the cases I'm going to present on. But let's see if we have any questions.
Yes, we have a few questions. So the first question that I received is, how can one physical indicate, quote, hypertension, when I understand the medical hypertension diagnosis requires 3 consecutive readings of 140/90 on 3 separate occasions during a 2-week period, according to the American Heart Association source?
I am not familiar with that source that is quoted. I am only familiar with the statute, and the statute says any evidence of hypertension. And if your pre-employment physical says hypertension, then you cannot, the heart law presumption is inoperable. That's what we go by. We don't go by, the American Red Cross. Sorry.
Yeah, and Ken, I can also add that for this case specifically, the member did have a diagnosis of hypertension and he was on hypertensive medication. So that's what we looked at for this specific person.
Okay.
Thank you.
Thank you. So the next question I have is, does the 6-year statute of limitations apply to modifications as well?
I'm not sure if they mean modifications pursuant to 91A. I'm not sure what they, any
Didn't
contractual
specify, but this
argument.
came early in the presentation, so probably one of the earlier cases.
Whoever asked that question, if you could just email me with a little bit more background, I'm happy to try to respond to it. The 6-year statute of limitations is applied to any contractual relationship, and a person's relationship when they start working in Massachusetts and become part of a public system is primarily contractual. So 6 years could apply, but I can't speak on the specific situation, so please email me.
Okay, next question. In Robbins versus SRB, when you say a board accepted the beneficiary form, should the board actually be voting to accept the beneficiary change? Or is the fact that the office took this in and date stamped the form adequate?
The latter. Yeah, they don't need to vote on any beneficiary forms that come in. Just the board, accepting it and stamping it is acceptance.
Thank you. On the buyback interest, is a member allowed to purchase the service back at half interest for 1 year after rehire?
I believe that is the rule.
Next question. I've had retirees that were impacted by anti-spiking due to salary increases from a salary compensation study done by the town. Do I need to recalculate them?
If the study was done by the town and it was not then made into an ordinance of some sort, then no, you don't need to. But if it was put into a bylaw or an ordinance that this is what the salary will be, then that is, that meets the exception of being approved by law. And you would need to recalculate. But a study on its own is not, approved by law. I forget exactly what the term is, but you would not need to. But if it's a bylaw or an ordinance, you would need to.
And this is in response to that earlier question is the attendee said no modification of a 3/8C. The question about the statute of limitations.
Oh, it would apply to something like that, a modification of a 3/8C.
Okay. Were the members in the last anti-spiking case, Willett and Houston versus Somerville and PERAC, members of a bargaining unit? And if so, was that at all a factor in Crabb's decision?
I'm not sure. Felicia, are you aware whether they were part of
I don't believe they were part of the bargaining unit. Crabb's decision just focused on the fact that it was officially done in an ordinance. Like Ken mentioned, that it wasn't just a salary study was done, so they used the salary and everybody just did general increases. It was because the town then officially took a position and made an ordinance requiring that it be done.
Next question. 3/8C cases are still pending, correct? Regarding the 6 years statute of limitations?
Yes.
Okay. And is there a difference between killed in the line of duty and died while on duty?
Yes. Killed in the line of duty is actually section 100A and section 100. And if you add section 9 into that, all three of them have different criteria for whether you are eligible to receive those benefits. So you need to look at the specific language of those statutes. I think section 100A says incident. It doesn't say assault. And I believe Mrs. Briley was awarded the 100A. So you do need to look at, and she was awarded the section 9. But because section 100 is so specific with that assault, unfortunately, Mr. Briley, was not assaulted, so she was not eligible to receive that benefit. But you need to look at the specific language of those statutes.
And that was the final question for you, Ken. I have one comment from an attendee that says that this presentation shows the diversity of cases that come up during the course of a year and the challenge to retirement boards to decide at the local level what decision is appropriate. So thank you for that comment.
I completely agree.
And with that, I will turn it over to Felicia.
All right, great. So the first case that I will be discussing deals with the definition of a veteran, the Hollenbach v. State Board of Retirement, which was a DALA decision issued in January of 2023. So the member appealed a state retirement board's determination that rescinded an earlier approval of his application to buy back military service time. So the state board determined that Mr. Hollenbach was actually ineligible to purchase military service because his discharge was quote unquote other than honorable, and therefore he did not meet the state definition of a veteran. So DALA issued a show cause for why the appeal should not be dismissed for failure to state a claim upon which relief can be granted. So DALA wrote that Chapter 32, Section 41H allows public employees who served in the military to purchase that service if they are a veteran as defined in Section 1 of the retirement statute. So Section 1 of Chapter 32 actually relies on the definition of a veteran found in Chapter 4. So Chapter 4, Section 7, paragraph 43 says that a veteran is any person whose last discharge or release from his wartime service as defined herein was under honorable conditions. So if a member was discharged under conditions other than honorable, they do not meet the state definition of a veteran and are not eligible to purchase military service. So in the response to the show cause, Mr. Hollenbach had explained that he was discharged as other than honorable because he had gone to an officer's party, ate some chocolate, and he didn't know that it was laced with marijuana. So he told the ship doctor, who requested a urine sample and confirmed that he had marijuana in his system. So that's why he received his other than honorable discharge. He asked Dalla to remove this event of 35 years ago from his record. So Dalla ultimately dismissed the case, found that it did not have the authority to revise the type of discharge a serviceman receives from the military. Because his DD-214 specifically said other than honorable, he was not a veteran, and that if he wanted to try to fight and get it changed to honorable, he should contact the VA to make the changes. The dismissal was not appealed, so this is a final determination of CRAB. All right, the second case, a McHugh v. State Board of Retirement, is also a Dalla decision from May of 2023. So Mr. McHugh was an assistant DA from 1984 until his retirement in July of 2022. So for the past 12 years, he had been assigned to the major felony unit as a senior prosecutor for homicide cases. He was on call to report to crime scenes late at night and on the weekends. The legislature appropriated money to the Massachusetts District Attorneys Association for the purpose of distributing funds to increase salaries of assistant DAs for 2019 and 2020 fiscal years. The legislature left the distribution, however, of the funds in the hands of the DA Association. So the state board had determined that Mr. McHugh's regular compensation in fiscal years 2019 to 2020 and 2020 to 2021 must be reduced as it violated the anti-spiking provision of Section 52F because he exceeded the average prior 2 years by more than 10%. In Section 52F, however, there are 3 exceptions to the anti-spiking rule. One is if you have an increase in compensation due to an increase in hours of employment, a bona fide change in position, or an increase in salary for a member whose salary is specified by law. Mr. McHugh argued that he met all 3 exceptions. Dalla determined that he did not qualify for any of the exceptions. He did not qualify for the hours of employment exception because he did not have fixed hours of employment. His position was expected to have long and late work hours as he was on call. He also did not have a bona fide change in position because even if he took on those additional duties, his duties were the same type that one would expect in that position and that were expected of the position. And finally, he did not qualify for the exception of an increase in salary specified by law, even though the legislature had passed these salary increases because the funds were used by the DA to give him raises and they were distributed with the DA's discretion. They were not specifically allocated to Mr. McHugh, so they did not find that it was actually a specified by law salary increase. So Mr. McHugh has filed an appeal of the Dalla decision with CRAB. Right. The next case is the Christopher C. v. Boston Retirement Board. So these are 2 consolidated cases from Dalla issued on May 5th. So you're going to notice Dalla has now started, especially with a lot of disability cases, offering the petitioners the ability to use pseudonyms. So this is, I just recently received several that have it marked, and even sometimes they don't even ask, they've just been replacing individuals' names with pseudonyms. So in this case, it's also really interesting as we're going to see that it deals with an ADR for a heart condition being awarded to a non-police or fire member. So this is just going to be a regular worker. It's actually a teacher. So the petitioner has worked for the Boston school system, started there in 1995, and his classes combined students with and without special needs. So in August 2015, testing indicated that he had some significant heart-related conditions, and he was placed on several heart-related medications. On October 19th of 2015, the petitioner's principal forwarded him an email from a parent claiming that her son had been watching pornography in the petitioner's classroom. The petitioner experienced this as very stressful because he felt that any allegations of a sexual nature could destroy his career and reputation. He testified that he immediately began to feel dizzy, have palpitations, and chest pain. He was taken to the ER that day and admitted for evaluations, and it was discovered that he may have had a heart attack at some point. They weren't sure if it was that day or at some point in his life he had suffered a heart attack because there was damage to his heart. He was off of work and returned in January of 2016. On January 14th of 2016, he intervened in an altercation between several students. He was really afraid of being attacked himself because a teacher in the school had recently been attacked and injured by several students. He sought accommodations, and the school administrator responded that there was no reasonable accommodations that could shelter him from aggressive student behavior. On the way home that day, he again experienced palpitations, chest pain, and shortness of breath. He was taken to the hospital and admitted and has not returned to teaching since that day. In September of 2016, he applied for ADR based on heart disease, arrhythmia, and PTSD. The Boston Retirement Board had asked him to supplement his application several times, and he did so in February 2017 and November of 2017. He underwent medical panel examinations in June 2017 for his cardiac conditions and then June 2018 for his mental health conditions. Both panels unanimously concluded that he was incapacitated, it was permanent, and it was the result of his asserted workplace injuries in 2015 and 2016. The board held a hearing, and the hearing officer actually did recommend that the board grant his ADR based on his cardiac conditions, but not his psychiatric conditions. The board attorney reviewed and disagreed with the hearing officer and noted that the cardiac application did not meet the statutory notice requirements, and he was not in the performance of his duties at the time of the purported injury. The member appealed, and DALA actually determined that the two medical panel determinations were decisive because they were neutrally construed panels. The retirement board had relied heavily in their argument on examinations performed for workers' compensation proceedings, but DALA did not find that they were neutral. DALA also determined that the petitioner here had two specific injuries on October 19, 2015 and January 14, 2016 that relied on for his cardiac and psychiatric applications. Especially for the cardiac condition, DALA had stressed that just because he suffered the palpitations on the way home for the last one, for the January 2016 incident, did not mean that it didn't stem from the incident that happened earlier when he was breaking up a student fight and his fear of being assaulted. So they determined that the medical panel confirmed the causation analysis that his cardiac conditions were brought to the point of disability because of the two alleged workplace events. The Boston Retirement Board has filed an appeal of this decision with CRAB. Great. The next case are two consolidated cases, Cohen and Vicari v. State Board of Retirement, issued by DALA on July 14th. Now, these are really interesting regular compensation cases. So the petitioners are state troopers who each receive stipends of $75 a week per their collective bargaining agreement for having to commute longer than 75 miles to work. Now, some employees were able to commute in a department motor vehicle and others used their personal vehicles. It was confirmed that Mr. Cohen commuted in a police cruiser, and it's believed that Mr. Vicari had driven a police cruiser as well. It does not appear that it was confirmed, but the DALA magistrate made it a finding of fact. The department motor vehicle policy lists that members with cruisers who are traveling to and from home shall undertake all necessary activities ordinarily performed during motor patrol. Additionally, the members are to be attired in their required duty uniform while commuting in the cruiser. If they come upon an accident, they must notify the relevant jurisdiction, assist at the scene, or investigate the accident if the state police patrol is not available. Both petitioners retired in 2019, and in March 2021, the board notified them that their retirement allowance would be adjusted as a $75 an hour stipend was not regular compensation. The State Retirement Board argued that the definition of wages specifically excluded travel. They also found that the regular compensation payments must be recurrent, regular, and ordinary, and must be for services performed. They said that no services were performed here other than commuting to and from work. Now, Dalla found that the payments were regular, recurrent, and ordinary, as they were received bi-weekly by both Mr. Cohen and Mr. Vicari. Dalla determined that because they commuted in a state vehicle, department policy mandated that they carry out their regular duties while commuting, such as wearing a uniform and investigating accidents if they came upon any. They were found to be on duty from the moment they left their driveway. Additionally, Dalla also found that the $75 an hour payments were not created to reimburse them for commuter-related expenses, which is prohibited from regular compensation, because here the gas and maintenance of the department vehicle was covered by the department. So the member was not spending any money on gas or maintenance of the vehicle. Since they performed a service for the department during their commute, Dalla determined that the $75 an hour they received is regular compensation. So this is interesting in the decision in that Dalla did not address if these payments would have been regular comp if the members had been commuting in their personal vehicle. They only stuck to whether or not it was regular compensation if they commuted in a department vehicle. So the state board has filed an appeal with CRAB regarding the Cohen case. All right, the next one is Vonnegut v. Massachusetts Teachers Retirement Board. It's a CRAB decision issued in September. So Ms. Vonnegut appealed a Dalla decision that had affirmed the decision of the Teachers Retirement Board to exclude stipends related to her work as the administrator of the Brooklyn Public Schools Early Education Extension Summer Program from her regular compensation. So Ms. Vonnegut worked as an early childhood program coordinator at the Brookline Public Schools from 1988 until her retirement in June 2014. So she started working as the administrator of the Early Education Extension Summer Program in 2001. As the coordinator of the early childhood program, she supervised employees, observed classrooms, and monitored student progress. As the administrator of the summer program, her duties were the same, except she did not perform teacher evaluations or conduct IEP meetings. Ms. Vonnegut's employment CBA provided a stipend for the administrator of the summer program. Now, Dalla found that administering the summer program was not a core duty of Ms. Vonnegut's position as the coordinator, but was an additional service. And then looking at the additional service, it failed to satisfy any requirements under the teacher's regulations, as it was not a public day school. The additional service was not performed during the school year, and her CBA did not require her to work 11 to 12 months per year. CRAB reversed the Dalla determination and held that Ms. Vonnegut's work as the administrator of the summer program was a core duty of her position as the coordinator. CRAB found that the summer program was subject to the Department of Early Education and Care regulations that required a full-time school-age administrator to run the program. Ms. Vonnegut never applied for the position, but was expected to take on these duties in her capacity as the early childhood extension coordinator. CRAB also found that her job description specifically reflected the task of planning and supervising the summer program. So it was determined that the stipend payments were recurrent payments for her services, as she was expected to and did run the summer program from 2001 until her retirement. The stipends were not bonuses, overtime, or ad hoc payments. They were paid for additional duties as it was part of her regular job. So CRAB determined that her base compensation was the salary received as well as a stipend for administering the summer program. We were able to confirm with CRAB that they have not received notice that this was appealed. However, the last day to notify CRAB would be January 26, 2024. So we're not entirely sure if this has been appealed or not. The second case is a Superior Court case issued in July, Habib and Stoff v. CRAB and the State Board of Retirement. Now, this case also deals with regular compensation payments. So the plaintiffs are 7 physicians, all of whom are former members of the clinical faculty and group practice at the UMass Medical School. They appealed the CRAB decision, which upheld the State Retirement Board's determination that certain supplemental pay received by them was not regular compensation. So in 1962, the legislature created the UMass Medical School. In 1974, it was recognized that the compensation was too low and that they needed an increase in order to obtain better physicians and clinical staff. In response, the legislature enacted Chapter 733, which established a group practice plan as well as a fee-generated trust fund from which the members of the group practice would be paid in addition to their base salary. Section 6 of Chapter 733 specifically stated that in computing state retirement benefits for those who receive both an annual salary and compensation from the trust fund, consideration would only be given to said employee's annual base salary and not the payments from the trust fund. In 1991, the legislature passed Chapter 142, Section 20, which amended the language and allowed the trustees to create a salary schedule without reference to any state salary schedule. The legislation made no changes to the language of Chapter 33, and it was still considered to be applicable. In 1997, the legislature again made changes and privatized the provision of clinical service by UMass Medical, and it became a new entity called UMass Memorial Healthcare Incorporated. Now, certain clinical faculty members were allowed to remain UMass Medical employees and remain in state service, and it was determined that in 2008, it was set that the trust fund would be officially dissolved. Well, there was a lot of setbacks, and the trust fund was not officially dissolved until September of 2011. Once it was dissolved, and actually prior to it being dissolved, the state board had opined that once the trust fund was officially dissolved, there would no longer be a cap on pensionable compensation, as the restrictions of Chapter 733 would no longer apply. The state board determined that individuals would now need to pay retroactive contributions since what was previously deemed non-pensionable was now pensionable. Here, though, at the time the trust fund was dissolved in 2011, all of the plaintiffs had retired at different times between 2008 and 2011. So the retroactive contribution requirement was never applied to them. As such, the State Retirement Board had issued rulings that excluded the plaintiffs' trust fund compensation from the calculation of their retirement benefits. The plaintiffs appealed, and DALA affirmed the State Retirement Board's termination. Crabb further affirmed the DALA decision by holding that the supplemental pay was not regular compensation because Chapter 733, the governing legislation of the trust fund, specifically prohibited the payments from being included in the calculation of the retirement benefits. In its decision, the Superior Court agreed with both Crabb and DALA and found that Chapter 733 was applicable to the plaintiffs because they are employees of the UMass Medical and had received compensation from the trust fund pursuant to Chapter 733. The Superior Court also found that the legislative changes in 1991 and 1997 did not supersede Chapter 733, and so it was still a valid law that governed the trust funds. The court also determined that it was undisputed that the trust fund continued to be in active use until 2011 and continued to fund part of the plaintiff's compensation. Now, the plaintiffs argued that it was really not fair that they were considered as a second class of citizen, as a second class of people, since they retired and would not receive the benefit of the additional compensation in their retirement contributions that other individuals might be receiving now. However, the court found that the plaintiffs chose to retire or resign voluntarily before the ability to get the trust fund payments counted as regular compensation. They were on notice that they would be eligible to count those payments as regular compensation after the last merger required transfer transaction, which was AKA the trust fund being dissolved. It was easily established prior to 2008 or in 2008 that the trust fund was set to be dissolved at some point. And it was then later determined that it would be in 2011. So all of the plaintiffs were on notice that if they waited until the trust fund dissolved in 2011, they would be able to count that as regular compensation, but they refused to wait. They'd also raised a due process violation, but the court determined that there was no due process violation as the plaintiffs, because of Chapter 733, never possessed the right for their trust fund compensation to be considered regular compensation and never established a right to the increased pensions that they now seek. Several plaintiffs have appealed this decision to the appeals court, so it'll be interesting to follow this. We'll probably having a presentation whenever we get a decision from the appeals court. All right, the next case is the Revere Retirement Board v. PERAC, which is DALA decisions issued on November 3rd. So for these cases, we're going to be looking at a dual member provision. So in February 2016, Mr. Milizano joined the Revere retirement system while he was a member of the Lowell retirement system. Prior to his retirement, he selected option A from Revere and option B from Lowell. In December 2019, he applied for superannuation retirement. And in May of 2020, PERAC approved the Revere's calculation of Mr. Milizano's retirement under option A. After we approved it, we realized that we needed to withdraw the approval And we informed Revere that since Mr. Lozano had selected option B in Lowell when he was going to retire, he had to retire under the same option with Revere. The Revere retirement system had requested further guidance, and we provided them with an opinion letter focusing on the language of Section 5.2E, which is the dual member provision in Chapter 32. So under Section 5.2E, we determined that a dual member will receive a superannuation retirement allowance. So that this meant that only one retirement allowance is paid that is equal to the sum of the benefits from both systems. While Section 5.2E does state that the member will be treated as if they were retiring solely from each system, they are still only retiring once and receiving one retirement benefit. So a dual member must have the same effective date of retirement and is not eligible to receive two different types of retirement allowance from each system. Therefore, this also meant that since it's treated as one benefit, a dual member must choose the same option selection from each system and list the same beneficiary. We determined that this interpretation provided uniformity across Chapter 32 as it was consistent with how every other member is retired. In this decision, DALA rejected PERAC's interpretation and concluded that a dual member who retires under Chapter 32, Section 5.2E can choose different retirement options from each system, as there is no prohibition by statute, regulation, or PERAC policy. That DALA found that while Section 5.2E does indicate that a member will receive a superannuation retirement allowance, it must be read in conjunction with the remaining language that indicates that the allowance is calculated as though the member were retiring solely from each system, and that each system shall pay the superannuation retirement allowance attributable to membership in that system to the member. So because of that language, DALA determined that there was no proven increased financial burden to either system if a dual member chose a different retirement option in either system, and that the legislative history surrounding the enactment of Section 5.2E supported its conclusion that a dual member can choose different retirement options from each system. PERAC has not appealed this decision, so now this is a final determination of CRAB. All right. So next case is Janet Walsh and PERAC v. the Reading Retirement Board. This is a DALA case that was issued in July. So any member who has retired from a Chapter 32 retirement system under Sections 5 or 10 can be reinstated to service under the requirements of Chapter 32, Section 105. So in 2010, Ms. Walsh retired from the Massachusetts Water Resources Authority. And then on September 3rd, 2019, she submitted to MWRA a signed application for reinstatement to service, as she is just recently hired by the Reading Municipal Light Department with a start date of September 26, 2019. On September 30th, 2019, she submitted a letter reaffirming the acknowledgement of the buyback procedure and requested it to either occur via installment payments for a period of less than 5 years or a lump sum payment, depending upon a decision from PERAC of whether she could use a rollover. After starting her employment, the Light Department initially withheld retirement deductions. However, that was stopped when they were instructed by the Reading Retirement Board not to take any deductions until her reinstatement had been confirmed. On November 15th, 2019, PERAC informed the MWRA that a rollover was permissible for a lump sum payment under Section 105. On December 20th of 2019, Ms. Walsh was placed on the Town of Reading employee payroll again as the Reading Retirement Board determined that her installment plan became official on December 10th. On January 22nd, 2020, Ms. Walsh made her final rollover payment to the MWRA of her previously received retirement allowance. In June and October 2020, PERAC was contacted by both at the MWRA, Ms. Walsh, and the Reading Retirement Board, and we issued 2 opinion letters on this matter. We opined that Ms. Walsh's date of reinstatement should be September 3rd, 2019, as that was when she entered into a signed and binding repayment agreement and waived receipt of retirement allowance. In March of 2021, the Reading Retirement Board informed Ms. Walsh that they were keeping her reinstatement date as December 20th, 2019, and she filed an appeal. So Reading argued that Ms. Walsh's reinstatement date should either be on December 20th, 2019, when they determined that the installment plan was official, or on January 22nd, 2020, when she fully repaid her previously received retirement allowance. The Reading Board further argued that they were not provided with sufficient information by the MWRA to establish that an agreement to repay the retirement allowance had been established on September 3rd, 2019, because signing the application for reinstatement to service was not a valid contract. So in his decision, Dalla agreed with Ms. Walsh and PERAC's determination. They found that the application for reinstatement to service specifically indicates that the member's signature means that the date signed is the reinstatement date. Additionally, there was ample evidence that Ms. Walsh had agreed to repay her retirement allowance in either installment payments or lump sum pending a decision from PERAC concerning the use of a rollover. Dalla concluded that to do as the Reading Retirement Board suggested and delay a reinstatement date until the details of the repayment plan were established or until the repayment plan was completed would be inconsistent with the legislative intent and could require that an unretired member work beyond the 5 years noted in the statute. Dalla also agreed with PERAC and Ms. Walsh's interpretation of Section 105 that the statute requires only that the parties reach an agreement to reinstate, not that the agreement has to meet all the formalities of a contract. Dalla concluded that Ms. Walsh's date of reentry into service and her reinstatement date was September 3rd, 2019, when she officially waived her retirement allowance and completed the application for reinstatement to service. Now, the Reading Retirement Board did originally file an appeal of the decision with the Contributory Retirement Appeal Board, as well as filing a motion for reconsideration and clarification of the Dalla decision on the grounds that the reinstatement date should be September 26, 2019, when Ms. Walsh officially started working for the Light Department. In July, Dalla denied the Reading Retirement Board's motion for reconsideration or clarification, but it did confirm that Ms. Walsh's date to start accruing reinstatement service was September 26, 2019, which was her first day of work. As a result of that confirmation, the Reading Retirement Board withdrew its objections to the Dalla decision, and so the case is now considered a final determination of CRAB. All right, our next case we'll be looking at is a 91A case. So this is PERAC v. Daniel Parka and Barnstable County Retirement Board. It's 2 consolidated decisions issued by CRAB. So Mr. Parka started his career as a police officer in 1987. While a police officer, he was specifically trained in accident reconstruction. And so in 1990, he created a business named Barnstable Reconstruction, doing private accident reconstruction cases. During that time, his wife started working for the Barnstable Reconstruction business a few hours a week while also working full-time for a gas company. In 2004, Mr. Parka retired under accidental disability, and around the same time, his wife incorporated their old business, Barnstable Reconstruction, into Parka Collision Consultants, or PCC. And this business specialized in accident reconstruction and special investigation unit work. So both Mr. and Mrs. Parka have worked and continue to work for PCC since 2004. Now, under PERAC policy 19002, PERAC attributed 50% of PCC's business earnings to Mr. Parka, as it was determined that he generated profit for the business through his labor that was not appropriately represented in his W-2 wages. So we instructed the board to recover excess earnings for calendar years 2011 to 2015, and then 2018 to 2019. The board filed an appeal, and Mr. Parka joined the appeals. Now, the issues in these cases were whether Mr. Parka's labor, management, or supervision at PCC produced profits which earned him income in excess of the allowable earnings under Section 91A for calendar years 2011 to 2015, and 2018 to 2019. In its 2 decisions, Dalla had determined that Mr. Parka's contributions to PCC was limited, and he was not the individual responsible for the ongoing success of the business. It concluded that Mr. Parka did not generate any income for PCC through labor, management, or supervision, and therefore he did not have any excess earnings under Section 91A. In his decision, CRAB did agree with Dalla's determination and found that Mr. Parka's actual annual W-2 wage compensation was consistent with the value of his contributions to the business. And so he should not be attributed any ordinary business income from PCC. CRAB further affirmed Dalla's credibility determination and held that the testimony from Mr. and Mrs. Parka established that Mrs. Parka made the business decisions, assigned her husband his work, and oversaw the business development, managing their subcontractors. Importantly in the decision, though, CRAB did affirm PERAC's 50-50 split policy, policy 19-002, as a critical and permissible means to elicit cooperation, information, and documentation from retirees. CRAB determined that we did appropriately apply the policy here in the present case, but that it was just rebutted by evidence from the PARCAs. PERAC has not appealed these decisions, and so they are final determinations of CRAB. All right, in the last case I'll be discussing, I actually presented on this last year with the DALA decision, and now we have the CRAB decision. So this is Mystic Valley Regional Charter School, the State Retirement Board, and PERAC. This has to do with non-teaching members of a charter school. So Mr. Kravitz worked at the Mystic Valley Regional Charter School as a non-teaching employee. In January 2020, he applied for membership with the state board, which was denied because he was a non-teaching employee and ineligible for membership. Now, DALA concluded that Mr. Kravitz was ineligible for membership in the state board because he was a non-teaching employee of a charter school, and that case law clearly supported PERAC's position that non-teaching employees of charter schools are not eligible for membership in a retirement system. DALA also concluded that if the legislature had intended to allow non-teaching employees to join a retirement system, they would have done so during the several amendments made to Chapter 71. DALA found that stare decisis prevented Mr. Kravitz and Mystic Valley Regional from prevailing as PERAC's binding memoranda that we had issued on this, as well as the prior DALA decisions were persuasive authority entitled to full deference. Now, in its decision, CRAB also found that non-teaching employees of a charter school do not qualify for membership in a Chapter 32 retirement system because General Law Chapter 71, Section 89Y makes clear that only teachers in charter schools are eligible for membership in a Chapter 32 system, i.e. the Massachusetts Teachers Retirement System. CRAB agreed with DALA's reasoning that had the legislature intended to allow non-teaching employees to join a retirement system, they would have revised Chapter 71, Section 89Y to either expand or contract the class of employees eligible for membership in a retirement system during the many times that Section 89 had been amended throughout the last 3 decades. CRAB also affirmed its decision in Whipple v. Mass Teachers Retirement System from 2014 that had held that Chapter 71, Section 89Y emphasizes that teachers may both join and receive creditable service for their work in a charter school, not that the purchase of creditable service can be done outside the requirements of Section 3.5 by non-teachers. There have been some recent DALA decisions inferring that the non-teaching members could potentially use Section 3.5 to purchase creditable service. And here CRAB is affirmatively striking that down, saying in Whipple, we meant that only teachers can join and receive creditable service, not that non-teachers are able to purchase the creditable service. CRAB also held that charter schools cannot utilize Section 28.4 to establish their own retirement system under Chapter 32. So while employees of a charter school are considered public employees for purposes of collective bargaining, tort liability, and conflict of interest laws, the charter schools were created to have other powers available to a business corporation formed under Chapter 156B. Additionally, charter schools are eligible to create their own pension plans rather than petition to establish a retirement system in Chapter 32, Section 28.4. CRAB concluded that because charter schools are often managed by private companies and its management can vary considerably, the charter schools may not accept the provisions of Chapter 32, Sections 1 to 28 inclusive, as required by Section 28.4. CRAB also recognized that there might be possible federal tax qualification implications for the private sector plan should charter schools be allowed to join a Chapter 32 retirement system, and that those issues would be best addressed by the legislature. Now, when Mystic Valley Regional originally filed their appeal to CRAB, they had also filed an action for declaratory judgment with the Superior Court in February of 2023. So the Superior Court case was originally stayed pending this decision from CRAB. Mystic Valley has officially appealed this decision to Superior Court, and it's now expected that the cases will be consolidated and that this will join the other action for declaratory judgment.
Thank you, Felicia. So I do have a few questions for you. The first question I have, I think, was actually for Ken, because it's referring referencing an earlier case, it says if he had to increase his hours to get the cases closed, wouldn't that qualify for increase in hours given his employer knew he worked increased hours on the weekend?
I think that's actually for mine.
Oh, okay.
So no, it was expected of the position in the member's job description as I think he was a senior prosecutor. It was expected of him to be on call and report to crime scenes late at night and on the weekends. That was part of his official job duties. It wasn't any extra hours. And plus, he was not an hourly employee, he was salaried. So that's also what they focused on.
Okay, thank you. Next question, how can you determine the date she waived her benefit is the date of reinstatement when she wasn't even offered the job yet?
She was offered the job. She had an official job offer. It was just not starting until September 26th of 2019. But when she was offered the job and she accepted it, she immediately contacted MWRA.
If the other board does not provide the proper documentation for you to determine that member is in agreement as the board, hold on, let me reread this. If the other board does not provide the proper documentation for you to determine that member is in agreement as the board only received a blank signed form.
Yes, so it is not the determination of another board to determine whether another board has entered into an agreement with a member. If the MWRA established that they received a signed form from Ms. Walsh to enter into the reinstatement agreement, the MWRA determined that it was a valid signature and a valid agreement. It was not up to the Reading Retirement Board to evaluate the terms of the agreement. That was not their purpose. They have no control over what the MWRA decided.
Okay. In all Section 105 reinstatement situations, is the reinstatement to service date the date the reinstatement application is signed or agreement reached, and not the date of returning to work?
So the way the Dollar case was written, the reinstatement to service date is the date that the application is signed and submitted to the board. However, the date that you're going to start accruing reinstatement to service is going to be the day that the member starts. So in this instance, the date that her 5 years began was September 26, 2019, which was her first day of work. That's what Dala had clarified in the decision.
Okay. And that was the final question.
Natasha, if I could jump in.
Absolutely.
Going back to the case I talked about the salary increases being specified by law, our colleague Patrick Charles texted me a reminder that the pay equity law that went into effect a few years ago that called for the increasing salaries of certain female employees to match their male counterpart salaries, which is a very good thing. You should be paid the same. But unfortunately, an unfortunate result of that is that many female employees then tripped the anti-spiking provision. So we are in the process. We've actually tried to have any increase that was that happened because of the pay equity law should be an exception to the anti-spiking law. We're pursuing legislation on that, but as of yet, it has not passed. But we will continue to try to pursue that. And speaking of our colleague Patrick Charles, so look at what he made me. Okay, look at this. Okay, all right. Beautiful.
Back up, we can't see it. It's blurry.
This nice Trevette. Okay, this is coming out at Christmas time. Meanwhile, I get him like a 6-pack every year. Like he's considerate, and I'm just an inconsiderate loser. But anyway,
I don't get on Patrick's list.
Patrick is very talented, very talented. But anyway, sorry.
Thanks. Thanks for that, Ken.
You're making his head even bigger than it already is.
All right. Well, thank you everyone for joining us this morning. As I stated earlier, any board members who have joined us live, I will send the attendee list to Rose and she will update your account in Prosper. Thank you, Rose. Excuse me. Thank you, Ken and Felicia, for very informative presentations. all of the attendees, you will receive a survey in your browser when we close this window. We would appreciate you taking 5 minutes to provide us with some feedback because we're constantly looking at ways to improve these webinars for you. So we would appreciate you doing that now. And if you don't have time to do it now, you can do it when you receive our thank you email tomorrow. So again, have a great rest of your day and thanks for joining us today. Take care.
Thank you, everyone.
Thank you.